The bench on my front porch wasn't anything special. Just a simple wooden seat where I like to tie my shoes in the morning, or sit with a cup of tea when the weather was calm. It wasn't decorative, it wasn't flashy, and it certainly wasn't hurting anyone. So when the HOA sent me a violation letter claiming the bench was non-conforming exterior furniture, I honestly laughed. It felt ridiculous. But the laughter faded when I saw the fine attached $75 if I didn't remove it within 5 days. The strangest part? That bench had been there longer than I had owned the house. I started with the usual approach. I emailed the board politely, explained that the bench had been part of the home when I purchased it, and asked for clarification. No reply. 2 days later, another notice arrived with a larger fine and a warning about further action. That was when annoyance shifted into resolve. I went back through the home inspection photos from my purchase. The bench was clearly visible. So I dug deeper. I checked the listing. Still there. Then, out of curiosity, I reached out to the previous owner. She responded within an hour and told me something the HOA probably didn't. Do you want me to know? The bench had been installed years earlier as part of an accessibility accommodation for her elderly mother, who had mobility issues and needed a stable seat while entering the home. That detail changed everything. Under federal law, accessibility accommodations once installed cannot be removed unless the homeowner requests it. And HOAs are explicitly barred from forcing their removal. I gathered everything: inspection photos, listing photos, emails, and the previous owner's written statement. I also printed out the relevant section from the Fair Housing Act, highlighting the portion regarding accessibility features. I sent all of it to the board with a calm, respectful message asking them to rescind the violation and confirm they understood the legal implications. Instead of acknowledging the documentation, they sent me a curt email saying they would review it at the next meeting. That was fine, I could wait. The meeting room was fuller than usual when I walked in. A couple of neighbors nodded at me. I guess the HOA had been busy with their notices lately. When it was my turn to speak, I didn't make a scene. I simply explained the history of the bench and the law that protected it. I handed the board my folder of documents. One board member skimmed through everything. And I'll never forget the moment her expression shifted from confusion to realization. The president of the HOA cleared his throat, adjusted his glasses, and said they would look into it. The inspector who originally approved the bench years ago happened to be present at the meeting. He recognized the photos immediately and confirmed the accommodation. That settled it. Within 10 minutes, the board voted unanimously to withdraw the violation, waive all fines, and issue a written reminder to all board members about accessibility protections. The bench is still on my porch today. I sit on it most evenings now, not just because it's comfortable, but because it reminds me that standing up for yourself doesn't require anger. Just patience, clarity, and the willingness to ask the right questions.